Your fate once rested on swallowing a cursed piece of cheese. Medieval courts relied on bizarre rituals to govern every human experience, from birth to death and beyond. This video uncovers 25 obsolete legal ceremonies that decided innocence, ownership, and destiny in ways that seem unthinkable today. You will discover a forgotten legal world where corpses stood trial, land was transferred with a clod of dirt, and your guilt could be proven by a boiling kettle. We will explore why societies trusted duels over evidence and how a church bell's toll held the force of law. What does justice become when it is built on faith instead of facts? A hand enters the boiling water. In the stark silence of a medieval court, this was the ultimate test of truth. Known as trial by ordeal, this legal ritual placed a person's fate directly into the hands of God. The accused would grasp a red-hot iron or plunge their arm into a cauldron of searing water. Their wound was then bandaged. After 3 days, if the injury showed clear signs of healing, God had proclaimed their innocence. If it festered, their guilt was sealed. This brutal practice was not chaos, but a highly regulated ceremony overseen by priests. Every prayer, every measurement of the iron or water temperature was prescribed by church law, merging divine appeal with earthly judgment. Consider the psychological torment of those 3 days of waiting, your entire future hanging on the state of a burn. This system was built on an unshakable belief that the divine would not allow an innocent person to be harmed. Without forensic science or modern evidence, truth was a matter of faith and justice a spectacle of pain. How would you bear such a burden, knowing your life depended on a miracle? This profound reliance on supernatural verdicts set the stage for another dramatic legal ritual, where combat itself became a form of testimony. Steel rang out on a field of honor, transforming personal grievance into divine verdict. Trial by combat, the judicial duel, allowed 2 adversaries to settle their dispute not with documents or witnesses, but with sword and shield. This was not random brawling, but a meticulously choreographed legal ceremony. Originating in ancient Germanic traditions, it became codified in legal texts across Europe, like the Sachsenspiegel, which laid out the precise rules of engagement. A knight accused of a crime could formally challenge his accuser, and their physical clash was believed to be guided by the hand of God, with victory serving as absolute proof of a just cause. The entire event was a public spectacle, overseen by officials to ensure the combatants adhered to the strict protocols governing weapons and conduct. Yet this system inherently favored the strong, the young, and the wealthy who could afford the best armor, intertwining legal success with martial skill and social standing. In 12th century England, knights under King Henry II famously dueled over contested land claims, their personal victory instantly transferring property rights. What does this reveal about a society that trusted armed conflict over collected evidence? It created a justice system where a nobleman's strength or a warrior's training could outweigh factual innocence, cementing violence as a legitimate, even holy, tool for resolving disputes among the elite. This reliance on the body as an instrument of law finds a quieter, yet equally strange, parallel in the next ritual, where guilt or innocence was determined not by a sword's edge, but by a simple piece of food. A dry piece of bread or cheese could seal your doom without a single weapon drawn. This was the trial by the morsel, the coarsened, a deceptively simple test where an accused person had to swallow a consecrated piece of food. The belief was absolute: if you were guilty, God would constrict your throat and prevent you from swallowing, while the innocent would consume it without any trouble. This ritual was most common in Anglo-Saxon and Norman England, a sacred ordeal often administered inside a church by a priest to determine guilt in cases like theft or false oaths. The laws of King Ethelred the Unready directly reference this practice, embedding it in the legal fabric of the time. The psychological terror was the true engine of this test. Standing before a priest and a community that believed divine judgment was manifesting through your own body, the sheer pressure could easily cause a dry mouth and a tightening throat, creating a physical reaction that was then interpreted as a sign of guilt. Surviving court records from local villages tell of individuals exonerated or condemned by this very act. Your entire future, your reputation, your life could be decided by whether you could perform the simple, involuntary act of swallowing. What does it say about justice when fear itself becomes the executioner, and faith is measured by a bodily reflex? This intimate, almost invasive, connection between the human body and legal fate finds a chilling extension in the next arena of medieval law, where the accused was not even alive to defend themselves. Even the grave offered no sanctuary from the law. Medieval courts sometimes summoned a defendant who was already dead, placing a decomposing body in the dock to answer for its alleged crimes. These posthumous trials were solemn, macabre ceremonies designed to condemn a person's memory and strip their heirs of any inheritance. The most infamous example is the Cadaver Synod of the year 897, where Pope Stephen VI had the corpse of his predecessor, Pope Formosus, dug up, dressed in papal vestments, and propped on a throne to face charges. A deacon was even appointed to speak for the silent accused. After a full trial, the deceased pope was found guilty, his papal acts were annulled, and his body was mutilated and thrown into the river. Centuries later, the Inquisition continued this practice, trying deceased individuals for heresy, their bones sometimes exhumed and burned as punishment. Why would a society go to such grotesque lengths? The verdict on a dead person carried immense power. A conviction for treason or heresy meant the family's lands and wealth could be confiscated by the crown or the church. It was a powerful tool for dismantling rival dynasties and funding royal coffers. Beyond the material consequences, it was a profound act of social erasure, a public damnation meant to terrify the living into obedience by showing that no sin escapes judgment, not even in death. This obsession with ultimate accountability reveals a world where your legacy was as vulnerable as your life. If your very memory could be put on trial, then the final moments of your life became critically important, governed by rituals designed to secure your soul's future. The final whisper of a dying person held the power of a legal decree. In the dim light of a sick room, surrounded by family, neighbors, and often a priest, a medieval individual would perform their last earthly act, the deathbed bequest. Known as a nuncupative will, this was an oral testament spoken when death was imminent, a ritual that fused the law of the land with the urgency of the soul's journey. In the evolving common law of England, such spoken words could carry the same weight as a sealed document, provided a sufficient number of credible witnesses were there to hear them. The content of these final speeches was profoundly revealing. People distributed property, settled old debts, and most critically, made generous gifts to the local church to fund prayers for their soul, a direct investment in their own salvation. Manorial court rolls are filled with cases where these spoken wishes were later presented and enforced, the witnesses recounting the dying person's exact words to a judge. But this informality was a double-edged sword. Without a written text, memories could differ, leading to bitter inheritance disputes among surviving family members. Can you feel the immense pressure in that room, the dying person striving for clarity while the witnesses strained to memorize every syllable, knowing their recollection would become the final law? This practice reveals a society that saw death not as an end, but as a legal and spiritual threshold that had to be crossed with affairs in perfect order. Just as the end of life required a formal legal ritual to ensure a smooth transition, so too did its very beginning, where the first cry of a newborn was met with ceremonies to define its place in the world. A new mother's first steps back into her community were not a simple walk, but a formal procession. She was led to her local church for a ceremony known as churching, a ritual of purification and thanksgiving that followed childbirth. Rooted in ancient Judeo-Christian traditions of ritual purity, this practice was fully codified in medieval canon law, transforming a biological event into a matter of legal and spiritual consequence. A woman was expected to undergo this blessing before she could resume her marital duties or fully participate in communal life. Her failure to appear for churching could cast a shadow of moral suspicion over her and, more critically, raise legal questions about her child's legitimacy, which had direct implications for inheritance rights. The ceremony itself involved specific prayers of thanksgiving and a symbolic cleansing, often requiring a payment to the priest, firmly linking it to the financial and judicial structures of the local parish. Parish records from England to France are filled with accounts of these payments and the women who made them, documenting the church's profound authority over the most intimate aspects of family life. This ritual powerfully reinforced the era's gender roles, framing a woman's body after birth as something that required official sanctification to re-enter society. What does this reveal about a system that legally mandated a ceremony to declare a woman clean? It demonstrates how medieval law extended its reach into the female body itself, governing not just actions but the very transitions of life. The public blessing of a mother was just one part of a larger legal framework that sought to control the beginning of life, a framework that made the determination of a child's legitimacy one of the most consequential judgments a court could make. The birthing chamber itself could become a crowded courtroom. Under the practice known as the bed of childbirth, a woman in labor was surrounded not only by midwives and family, but by a formal assembly of community witnesses. Their presence was a legal requirement, not a medical one, designed to provide irrefutable proof of the newborn's legitimacy and its right to inherit. In noble households across Europe, from France to the Holy Roman Empire, this ritual was codified in legal customs like the Coutumes de Beauvaisis, which detailed the need for such verification. The entire event was a carefully orchestrated performance of lineage, with the witnesses serving as human seals of authenticity on the child's identity. Their sworn testimonies, recorded in manor court rolls, could later be summoned to block any rival claimant who might argue the child was a supposititious heir, a secretly swapped infant. Medieval chronicles recount succession crises where the testimony of those present at the birth settled epic disputes over castles and titles. Can you feel the immense pressure in that room, the convergence of intense physical ordeal and cold legal scrutiny? For the mother, there was no private moment of birth, only a public declaration of lineage. This invasive procedure reveals a world where the continuity of power was so fragile it had to be anchored in the witnessed reality of the body. Every cry of a newborn heir was accompanied by the silent testimony of observers, their memories becoming the legal bedrock for future claims to land and title. This legal obsession with the moment of birth naturally extended to the most vulnerable of all, those who never drew a single breath. A woman's private certainty became a matter of public record. The moment she first felt the stirring of life within her, an event known as the Quickening, was not merely a biological milestone but a legal turning point. In the eyes of medieval law, this subjective internal experience could define the legal status of her unborn child, transforming a flutter of movement into a declaration of personhood. English common law, deeply influenced by church doctrine, often held that quickening marked the moment the fetus received a soul, granting it certain protections and rights. This single event could reshape entire futures. In a contested inheritance case, a widow's sworn testimony that she had felt her unborn child quicken could secure the estate for her son, blocking the claims of other relatives. Conversely, in tragic instances of a miscarriage following an assault, proof of quickening could elevate the charge from a simple battery to a more serious crime, recognizing the loss of a potential life. The woman's body, therefore, became a living legal document, her personal sensation carrying the weight of sworn evidence before a judge. This granted women a unique and powerful form of testimony, yet it also placed their bodily autonomy under intense legal scrutiny. How could a court truly verify such an intimate, internal event? It relied entirely on the woman's word, making her credibility the sole foundation for monumental decisions about lineage and property. This profound reliance on the unseen reveals a legal system grappling with the very essence of life, using a mother's feeling as a compass to navigate the unknown. Just as the law sought to define the beginning of life through the ritual of quickening, it also meticulously structured the unions that created it, turning marriage itself into a complex public performance. A simple handclasp before neighbors could forge a marriage as binding as any church ceremony. This was handfasting, a ritual union where a couple joined hands, exchanged vows, and in the eyes of their community became husband and wife. Rooted deeply in ancient Celtic and Germanic traditions, this practice thrived across rural medieval Europe, offering a form of marriage accessible to those who lived far from a church or could not afford a priest's fee. The legal power of this ritual resided in its verbal contract, sworn before witnesses, and its physical consummation. Manorial court rolls from England are filled with cases where these unions were legally enforced, determining a widow's right to her cottage or a child's claim to a father's tools. Yet this very simplicity was its greatest weakness. Agreements were sometimes made for a trial period of a year and a day, after which the couple could choose to make their bond permanent or go their separate ways. This flexibility met a social need, but it also sowed the seeds for bitter legal confusion. Was a handfasted spouse from one village still married if they moved and handfasted with another? The lack of a central record meant disputes over inheritance and accusations of bigamy were common, pitting memory against memory in the local court. What does this tell us about justice when a marriage could be made or broken with a handshake? It reveals a legal world that was deeply personal and locally controlled, where the spoken word, witnessed by the community, carried the force of law. This informal approach to one of society's most fundamental contracts highlights a constant tension between flexible tradition and the need for clear, unbreakable rules, a tension that would eventually push the church and state to impose much more rigid and public marital ceremonies. A substitute groom could speak your wedding vows for you. In the high-stakes world of medieval politics, marriage by proxy allowed a royal union to be sealed even when the groom was hundreds of miles away, commanding an army or ruling his own lands. This was not a symbolic gesture but a legally binding ceremony, fully recognized by both church and state. A stand-in, often a nobleman or ambassador, was granted specific legal powers to act on behalf of the absent spouse. In one famous instance, Margaret of Austria was married by proxy to the Duke of Savoy, with the envoy performing the entire ritual in his stead. The ceremony followed a precise script. The proxy would place the wedding ring on the bride's finger and recite the solemn vows as if he were the groom himself. This act, witnessed by dignitaries and documented in formal treaties, instantly created a political alliance, merging territories and claims. the marriage was considered legally valid from that moment, though it was typically followed by a second, private ratification when the couple finally met, often centered on the physical consummation that solidified the bond. These unions were the glue of international diplomacy, preventing wars and forging empires, but they placed an immense personal burden on the individuals, especially the bride. She was legally married to a man she had never seen, her fate and her country's security now tied to a stranger's portrait and a set of diplomatic instructions. What happened if, upon meeting, the couple found each other intolerable, or if one party later denied the proxy's authority? Church courts were filled with such disputes, where the lack of personal consent could threaten to unravel carefully constructed treaties. The proxy marriage stripped the union down to its bare contractual essence, revealing that for the nobility, marriage was often less about personal choice and more about the cold, hard mechanics of power. This legalistic view of marriage as a binding contract naturally invited questions about how such a contract could ever be broken, leading to rituals not for creating unions but for dissolving them. A husband could be summoned to prove his manhood before a panel of experts. Annulment on the grounds of impotence was one of the most invasive legal rituals of the medieval world, a desperate escape hatch from a marriage that could not produce an heir. Rooted in canon law, this process required a spouse, most often the wife, to petition an ecclesiastical court and prove that the marriage had never been physically consummated. The stakes were monumental, for without consummation, the union was considered invalid, freeing the individuals to remarry and, they hoped, secure the lineage so crucial to inheritance and power. The proof, however, plunged directly into the most private of matters. In some notorious cases, the court would order a physical examination of the husband by a team of midwives and physicians, or even demand a public demonstration of his virility. More commonly, the testimony of witnesses was required, sometimes involving servants who were questioned about the couple's intimate life or the state of their bed linens. The records of the papal court, the Rota, contain agonizing accounts of these proceedings, where personal shame was the price of legal freedom. For a noblewoman, succeeding in such a case meant reclaiming her life and her potential to bear an heir for a new house, but the social stigma could linger forever. What kind of justice is this, where a person's most intimate self is put on trial to satisfy the law's demand for progeny? This humiliating process reveals a society where the church's authority reached into the marital bed, and the legal necessity of a bloodline could override any notion of personal privacy. Just as the law scrutinized the beginnings of a marriage with such intensity, it also developed elaborate rituals to manage its end, turning the finality of death into another arena for legal performance. The sound of a bell carved a legal fact into the air. Across the fields and lanes of a medieval parish, the death knell announced a life's end with a solemn, deliberate toll. This was not merely a call to prayer, but a binding public notice, a sonic document that set in motion the machinery of inheritance and law. Manorial customs and town statutes often required the bell to be rung, preventing families from conducting secret burials to hide a death and evade feudal dues or creditors. Its pattern was a coded legal bulletin, 3 strokes for a man, 2 for a woman, a frantic peal for a child, telling the community who was gone and what social and economic void now needed filling. Parish records from places like St. Mary's in Nottingham detail specific fees for the knell, embedding the ritual in the local economy. Upon hearing those tones, neighbors knew they might be summoned as witnesses to a will. Creditors could prepare their claims, and the manor court would soon begin the process of transferring property. How many legal dramas began with that single, mournful sound? This auditory ritual wove law into the fabric of daily existence, making every member of the community an involuntary participant in the administration of justice. The bell's echo ensured that death, the most personal of events, was also a profoundly public and legal affair, a transition managed not in private grief but under the listening ear of the entire village. A fugitive's desperate hands gripped the cold stone of a church altar, his breath the only plea in the sacred silence. This was the claim of sanctuary, a legal ritual that transformed holy ground into a temporary fortress against arrest or vengeance. Rooted in the mercy of early Christian traditions and formally codified in laws like those of King Ethelbert of Kent, this practice offered a fragile shield in a brutal world. An individual accused of any crime, from theft to murder, could race to a designated church or abbey and claim protection. Upon arrival, they were granted a set period of safety, traditionally 40 days, during which the church authorities would provide basic sustenance and negotiate with pursuing secular officials. The fugitive faced a stark choice: confess their crime and swear to abjure the realm, leaving the country forever, or stand trial when the sanctuary period expired. Chronicles from Norman England recount thieves and outlaws using this very loophole, delaying their fate and sometimes securing a path into permanent exile. This ritual created a tense balance between the church's spiritual authority and the crown's demand for justice, a visible struggle between mercy and law playing out at the church door. Why would a society so focused on order uphold a practice that could shelter the guilty? Sanctuary acknowledged the possibility of redemption and provided a crucial pressure valve, preventing cycles of blood feud and offering a controlled, lawful alternative to mob violence. It was a testament to the belief that even justice could sometimes benefit from a pause, a moment of holy reflection. This idea of a spiritual test determining legal outcome finds a strange and eerie parallel in the next ritual, where the accused was not a living fugitive but a silent corpse laid upon a bier. The silent corpse itself could rise as the final witness. In the hushed gloom of a church, a murder suspect was led toward the body of the slain, compelled to lay hands upon the cold flesh in a ritual known as the trial by Bier. The community watched, breath held, for the ultimate sign, a fresh flow of blood from the victim's wounds, believed to be provoked by the killer's mere presence. This practice, cruntation, was formally acknowledged in Germanic legal codes like the Sachsenspiegel and persisted in rural European courts for centuries. The ceremony was a solemn, terrifying fusion of faith and forensics, where a physical reaction was interpreted as a divine verdict, bypassing any need for motive or alibi. Can you sense the sheer dread of the accused, forced to approach the person they may have killed, their own life resting on the state of a decomposing body? The pressure was immense, and the results were tragically unreliable. A body might seep fluids naturally, or a nervous onlooker could misinterpret a shadow as movement, yet these observations were enough to send a person to the gallows. This ritual reveals a world that saw death not as a final silence, but as a state of latent awareness, where the departed retained a terrible power to point a finger from beyond the grave. It was justice orchestrated by the dead, a system built on the chilling belief that the earth itself would cry out against a hidden crime. This reliance on supernatural accusation through direct contact finds a fascinating contrast in the next legal arena, where a person's fate rested not on touching a corpse, but on the power of their own spoken word. Your word was your bond, and a chorus of voices could make it unbreakable. In a medieval court, an accused person did not always face a hot iron or a duel. They faced the challenge of gathering friends. This was Compurgation, the wager of law, a ritual where a defendant swore their innocence while a group of oath helpers or compurgators stood beside them to swear that his oath was clean. The number of these supporters was not arbitrary. It was fixed by ancient legal codes like the Salic law, often demanding 12 men for a serious accusation. These men were not witnesses to the crime, they were witnesses to the accused's character, swearing to their belief in his honesty before God. Successfully swearing the complex, formulaic oaths meant instant acquittal, while failure to produce enough supporters meant a presumption of guilt, often leading directly to a trial by ordeal. Manorial court rolls from England show this system in action, with villagers assembling to vouch for a neighbor accused of petty theft or trespass. This made justice a direct reflection of your social capital, your reputation, and the strength of your kinship network. A well-liked individual with a large family could easily muster the required oath helpers, while an outsider, a loner, or someone with a damaged reputation stood little chance regardless of the actual fact. How easily could such a system be corrupted? A wealthy person could pressure or pay others to swear for them, while a powerful lord could intimidate potential oath helpers into silence, turning a test of character into a weapon of social control. Compurgation reveals a legal world where truth was not an objective fact to be uncovered, but a social consensus to be performed. Your standing in the community was your greatest legal defense, and the spoken oath, multiplied by a dozen voices, held the power to erase any charge. This profound reliance on verbal contracts and public standing formed the bedrock for another set of rituals, those governing the more mundane but equally vital matters of debt and property. A glove passed from one hand to another could settle a debt as firmly as a signed contract. This was the law of wager, a ritual where a debtor would hand a symbolic object, like a glove, a knife, or a ceremonial rod, directly to their creditor. This act, performed in a bustling marketplace or before a gathered group of neighbors, transformed an abstract financial promise into a physical, undeniable fact. Urban charters and merchant law codes across Europe, from the statutes of London to the customs of German trade towns, explicitly recognized this ceremony as legally binding proof of an obligation. The object itself, often of little intrinsic value, became a powerful token representing the entire debt. The debtor could reclaim their glove or rod only upon presenting the full payment, making the object's return the final act that dissolved the agreement. Court records from medieval London are filled with cases where a trader produced the very knife given in wager to prove that a fellow guild member owed them money, the physical item serving as the primary evidence before a judge. This system created a public theater of trust where the entire community acted as witness to the transaction. But what happened if the debtor refused to pay and the creditor could not return the token? Breaking the wager was a serious offense, a public breach of faith that could lead to swift legal penalties, including seizure of goods or imprisonment. This elegant ritual made the invisible visible, turning the precarious nature of credit into something you could hold in your hand. In a world of verbal agreements and shaky memory, it provided a concrete anchor for commerce, proving that sometimes the simplest objects could carry the heaviest legal weight. This reliance on symbolic objects to represent intangible rights found its most profound expression not in the marketplace, but in the fields where the future of a family's livelihood was transferred with a clump of earth. A clod of earth and a simple twig could secure your family's future for generations. This was the livery of Sacin, the solemn ritual that legally transferred ownership of land through physical symbols, not a signed parchment. In a field surrounded by neighbors, the current lord or landowner would pick up a piece of turf from the soil and a branch from a tree, placing them directly into the hands of the new owner. This act, performed on the very property being conveyed, was a binding contract under English common law, with the clod representing the ground itself and the twig symbolizing everything growing upon it. The entire ceremony was a public performance designed to leave no doubt in the community's mind about who held the title. Manorial court rolls from the 12th century onward meticulously document these transfers, noting the names of the witnesses whose memories would be the final arbiter if the ownership was later challenged. Why would a society trust dirt over a document? In an era of widespread illiteracy, the physical ritual created an unforgettable sensory memory for all present, a living record more durable than ink. A flawed performance, however, could unravel everything. If the ceremony was conducted in the wrong location or without the required witnesses, rival heirs could launch lawsuits that dragged on for years, disputing inheritances and overturning lordships. This profound reliance on tangible proof reveals a legal world that understood truth as something to be seen and touched, a reality anchored in the very soil it governed. Just as this ritual used earth to define possession, the next legal ceremony would use walking to define a space, turning a simple path into a permanent boundary. Young boys winced as a willow switch struck their shoulders, but this was not punishment, it was education. Every year, entire parishes across medieval England embarked on a solemn procession known as beating the bounds, a walking legal ceremony designed to etch territorial borders into the minds of the community. Led by the priest and local officials, villagers would walk the exact perimeter of their parish, stopping at each boundary marker, a specific ancient oak, a carved stone, a bend in the creek. Here, the ritual turned physical. Children were lightly whipped or their heads were gently bumped against the marker, a sensory mnemonic to ensure they would never forget that precise location. The entire event was a legal performance, a living map created through shared experience and mild pain. Manorial court records from villages like Steeple-Aston show that this collective memory was later presented as evidence in disputes over grazing rights or contested fields. Why strike a child to teach them law? In a world without printed maps or formal deeds, memory was the primary legal archive, and physical sensation forged the most durable memories. This ritual transformed abstract lines on the land into a story written on the body, ensuring that every generation carried a mental blueprint of their community's legal identity. This profound reliance on communal memory for resolving disputes reveals a legal system built on participation, where every villager was a walking record of local law. But if the community could put its own borders on trial through this ritual, it also developed a parallel system for judging its most disruptive members, even when those members walked on four legs. A pig stood in the dock, clothed in a tiny doublet and breeches, facing a judge and jury for the crime of murder. This was not a festival pageant, but a genuine medieval court proceeding, where animals from pigs and rats to locusts were formally prosecuted. In the year 1386, a sot in the French town of Falaise was convicted of mauling an infant, sentenced to be maimed and publicly hanged, a sentence meticulously recorded in the municipal accounts. These trials, documented in the legal archives of Switzerland and France, were not mere superstition but followed the letter of the law, complete with appointed defense lawyers, witness testimony, and solemn verdicts. The belief was that animals, as part of God's creation, possessed a form of moral agency and could choose to commit sinful acts against the divine and human order. An infestation of locusts might be formally excommunicated by a church court, an attempt to drive the plague away through spiritual authority rather than pesticides. Why would a society devote such legal resources to prosecuting a creature? These rituals serve to restore a perceived moral imbalance, to purify a community shaken by a bestial crime or a blighted harvest by assigning blame through a familiar, formal process. The trial provided a narrative of justice and control in the face of chaotic natural events. Theologically, it reinforced the idea of a universe governed by divine law where every creature, even a lowly insect, was accountable. What does it reveal about justice when a pig is granted the same legal formalities as a person? It demonstrates a world where legal personhood was astonishingly fluid, extended even to beasts to maintain cosmic and social order. This same legal system, however, had very different rituals for dealing with human beings who lived on the fringes of that ordered society, individuals formally cast out from the community's protection. A human being could be legally erased with a single proclamation. Outlawry was the ultimate penalty for those who fled justice in medieval England and Scandinavia, a ritual of legal death that stripped a person of every protection the law afforded. After a formal accusation and repeated failures to appear in court, a judge would publicly declare the individual a wolf's head caput lupinum, placing them outside the human community entirely. This was not mere metaphor, it was a binding legal status. From that moment, the outlaw could be hunted and killed by anyone like a dangerous animal with no fear of legal repercussions. Their property was forfeit to the crown, their marriages were dissolved, and they were, in the eyes of the law, already dead. The Assize of Clarendon under King Henry II formalized this process, using it to pursue felons who evaded capture and to assert royal authority over a fractious nobility. How did it feel to hear your own name read in that public declaration, to know you were now a ghost to your former life, that every hand was turned against you? This ritual served as a brutal deterrent, but it also performed a deeper function for the community. By casting out the outlaw, the law reaffirmed its own boundaries, defining who belonged and who did not, reinforcing the very idea of citizenship through dramatic exclusion. A person only had rights because the law granted them, and those rights could be revoked in an instant, leaving only the raw state of nature. The stark finality of outlawry makes the next legal rituals all the more remarkable, for they detail the precarious and often humiliating paths back in from the cold. A confessed felon stood at the church door, clutching a simple wooden cross. This was the ritual of abjuration of the realm, a formal sentence of self-imposed exile that offered a sliver of mercy in a harsh legal world. In medieval England, a person who confessed to a serious crime like theft or manslaughter could choose this path, swearing a sacred oath to leave the kingdom forever, thus avoiding the gallows. The ceremony was meticulously recorded in coroner's rolls, detailing how the individual would vow to travel directly to a designated port, never to return on pain of death. They were given a single garment, a sackcloth tunic, and a wooden cross to signify their pilgrim status, a haunting figure departing from the only life they had ever known. 13th century court records from counties like Kent and Sussex are filled with such cases, where a thief or a man who killed another in a brawl took this desperate bargain. Why would a justice system so focused on order provide this escape route? Abjuration served as a crucial pressure valve, cleansing the community of a criminal element without the finality of bloodshed, while still satisfying the Crown's demand for a permanent solution. It was a ritual of removal, transforming a felon into a permanent outsider, a ghost in the legal landscape. The cross they carried was not a symbol of grace, but a public badge of their condemned status, marking them for every eye on their lonely trek to the coast. This legal exile balanced a grim pragmatism with a flicker of compassion, acknowledging that even justice could sometimes be served by banishment rather than the noose. This practice of formal exclusion to maintain order finds a fascinating parallel in a ritual designed not to banish individuals, but to contain the violent disputes between them. Your neighbor's crime could cost you your own freedom. In the heart of every medieval English village, the legal ritual of frankpledge wove a web of collective responsibility so tight that no man could escape its strands. Every adult male not of noble status was compelled to belong to a tithing, a group of 10 or more households bound by a solemn oath to uphold the law and guarantee each other's conduct. This was not a casual promise but a formal legal duty enforced through the view of frankpledge, a special court held periodically by the local lord or his steward. Manorial court rolls from the 12th and 13th centuries are filled with entries detailing these gatherings, where the entire tithing would be fined if one of its members was accused of a crime and failed to appear for trial. The system's roots stretched back to the laws of kings like Canute, designed to maintain order in a world with no professional police force. It transformed law enforcement into a communal project, making every man a guardian of the peace and a guarantor of his neighbor's behavior. This created a powerful incentive for communities to police themselves, to resolve disputes internally, and to track the movements of anyone who might bring a collective penalty down upon them all. But what happened when a tithing refused to vouch for one of its own, or when a member fled in the night? The entire group faced a heavy financial amercement, a fine that could cripple multiple families. This system fostered a deep, sometimes suffocating form of social order, where suspicion fell not just on the guilty individual, but on every person linked to him by legal oath. The constant pressure to conform and to monitor your neighbors forged a society where everyone was watching and everyone was accountable. This intricate network of mutual accusation and responsibility set the stage for a more personal legal ritual, where a single individual's word could formally set the wheels of justice in motion. Your own voice could be the formal start of a murder trial. In the stark halls of a medieval court, a victim of a violent crime or their surviving family stood and pointed a finger, launching an appeal of felony. This was not a state prosecution but a deeply personal legal ritual, a private lawsuit for a public wrong. Rooted in the legal traditions brought to England by the Normans, this process gave the aggrieved party the power to become a prosecutor, setting the wheels of justice in motion with their own accusation. The entire case rested on their shoulders, requiring them to pursue the accused present evidence and face the same risks as any other litigant. The rolls of the King's Bench from the 13th century document these dramatic confrontations, where a widow might appeal a man for the death of her husband, or a merchant might appeal a thief for stolen goods. But this power came with a heavy price. The accuser had to swear to the truth of their claim, and a failed appeal could result in their own punishment for making a false accusation. The stakes were ultimate, for if the appeal was for a capital crime like murder or rape and the defendant was convicted, the penalty was often death. This system created a formal channel for personal vengeance, transforming raw emotion into a structured legal duel. The case could be settled by the new method of a jury verdict or, in some instances, by the older, more visceral ritual of trial by combat, where the accuser and accused could literally fight it out, believing God would grant victory to the truthful party. What does this reveal about justice when it is powered by personal vendetta? It shows a society where the line between lawful process and blood feud was dangerously thin, where the state outsourced its authority to the passions of the wounded. The appeal of felony made the victim the engine of the law, but it also demanded they risk everything, their reputation, their finances, and even their life, in a high-stakes gamble where the outcome was anything but certain. This exhausting, all-consuming process of private prosecution makes the final ritual, the sovereign's act of mercy, not just a kindness, but a necessary release from the law's unforgiving grip. A parchment pardon could halt the executioner's axe in its final descent. This was not an act of casual forgiveness but a solemn legal ritual, the royal pardon, where a monarch's personal mercy was formalized into law. A supplicant, often on their knees, would receive a sealed charter, a document that had the power to annul a court's verdict, restore a convict's rights, and literally open the doors of a dungeon. These pardons were meticulously recorded in England's patent rolls, vast archives of royal grants that detail thousands of such acts of clemency. Monarchs issued them for many reasons: a soldier's loyal service in a foreign war, a political favor to a powerful noble, or even a public appeal sparked by a compelling story of misfortune. The ritual did not end with the handing over of the scroll. The pardoned individual had to present this charter to the local court that had convicted them, forcing the judges to acknowledge a power higher than their own verdict. This practice created a crucial balance within a brutally harsh legal system, allowing a king to temper the rigid application of law with personalized grace. It was a powerful tool for building political loyalty, transforming a condemned felon into a lifelong supporter of the crown. But this system was ripe for abuse. Pardons could be bought by the wealthy, creating a two-tiered system of justice where the rich could purchase their absolution while the poor faced the gallows. Entire communities might pool their resources to beg for a pardon for a well-liked neighbor, turning the royal mercy into a transaction. What did it mean for justice when the law's final word could be overturned by a single signature, available to those with the right connections or enough coin? The royal pardon ritual revealed that in the medieval world, justice was not always blind. It could be swayed by a whisper in the right ear or the weight of a heavy purse. This personal power to cancel a legal debt of blood finds a direct parallel in the next and final ritual, which offered ordinary people a way to cancel their financial debts and start anew. A dying nobleman's final charitable wish could be legally voided by a royal clerk. The law of mortmain, meaning dead hand, was a powerful legal barrier against the church's relentless accumulation of property through deathbed bequests. Enacted in England by the Statute of Mortmain in 1279, this law declared that no land could be given to any religious corporation without a specific license from the king himself. The ritual was one of bureaucratic inquiry. Royal officials would scrutinize the proposed gift, not to judge its piety, but to calculate its cost to the crown. Every parcel of land held by the church was land removed from the feudal system, a permanent loss of the knight service, the tax payment, and the reliefs that a secular lord would have owed upward to the monarch. Court records from the reigns of kings like Edward I are filled with cases where gifts were blocked or lands were seized back into the king's hand because this formal permission had been bypassed. Why would a society so devoted to faith deliberately restrict gifts to God's own houses? The answer lies in a brutal fiscal reality. The church never died and never paid inheritance tax. As these estates passed into its eternal ownership, the crown and the nobility saw their primary source of revenue and military power steadily draining away. Mortmain was a desperate legal ritual to staunch that flow, a secular counterweight to the overwhelming spiritual pressure of a deathbed donation. It was a dramatic manifestation of the eternal tension between the kingdom of heaven and the kingdoms of earth, fought not with swords but with charters and royal writs. This final ritual, the mortmain, brings our journey to a close. We have witnessed a legal world built not on cold evidence, but on fiery faith and tangible symbols, where justice was a performance, truth was a spectacle, and your very body could become a legal document. These 25 obsolete rituals, from the boiling kettle to the clod of earth, reveal a system grappling with the same eternal questions we face today: how to find truth, enforce order, and navigate the profound transitions of life and death. They show us that the law is never just a set of rules. It is a mirror of a society's deepest beliefs, its fears, and its most desperate hopes for order in a chaotic world. The world of medieval law was a turbulent river fed by three powerful streams: Roman order, Germanic custom, and Christian faith. When the Roman Empire in the West collapsed, its sophisticated written legal system did not vanish entirely. Instead, its remnants mingled with the vibrant oral traditions of the Germanic tribes, peoples who governed themselves through communal memory and spoken rites. Into this mix flowed the powerful current of Christianity, which provided a new spiritual framework and a universalizing force. This fusion created a unique legal landscape, one where a ceremony like trial by combat could exist alongside the meticulous property surveys of the Domesday Book. The great political upheavals of the era, like the Norman conquest of England, accelerated this blending, imposing new feudal structures atop older Anglo-Saxon customs. Meanwhile, within the Church, the Gregorian reform movement sought to codify and centralize canon law, creating vast collections that dictated everything from marriage to the rules of sanctuary. These written sources, from papal decretals to manorial court rules, reveal a society constantly negotiating between tradition and change. Law was not seen as a human invention, but as a reflection of a divine order. This is the crucial key to understanding every ritual. When a community watched a hand enter boiling water, they were not witnessing barbarism, but a sincere appeal to the ultimate judge. These ceremonies were the practical solution to a world without forensic labs or professional police, a way to resolve disputes, maintain social cohesion, and enforce control in a manner that everyone could understand and believe in. They addressed the deepest fears of a fragile society, fears of chaos, of hidden sin, and of divine displeasure. So the next time you hear of a corpse standing trial or a clod of earth transferring land, see it not as mere superstition, but as a profound attempt to build justice from the materials at hand: faith, community, and the unshakable belief that the universe itself would cry out against a lie. These 25 rituals form a forgotten legal universe, one where justice was performed, not just proclaimed. While their methods seem alien now, each one was a rational response to the world as medieval people understood it. They provided a structure for navigating life's most perilous transitions, from the cry of a newborn to the silence of the tomb, offering communities a way to manage conflict, assign blame, and maintain order in the absence of our modern tools. The true legacy of these ceremonies lies not in their strangeness, but in the fundamental human needs they reveal. Our own legal system, with its courtrooms and cross-examinations, is still answering the same eternal questions. How do we find truth? How do we enforce order? And how do we ensure that the powerful cannot simply trample the weak? The journey from trial by combat to trial by jury is a story of progress, but it is also a story of continuity, a centuries-long conversation about the meaning of justice itself. By studying these obsolete practices, we see the deep roots of our own laws and are reminded that the legal framework we take for granted is not fixed but constantly evolving. It must adapt to new understandings, new technologies, and new social realities. So, which of these rituals lingered in your mind the longest? Was it the accused swallowing a cursed morsel, the land transferred with a clod of earth, or the chilling spectacle of a corpse standing trial? Share your thoughts below, and let this exploration be a reminder that history is not just a record of dates and kings, but the story of our endless collective struggle to build a world that is fair. Thank you for joining this journey into the hidden corners of the past. For more deep dives into the forces that shaped our world, be sure to subscribe. Carry these stories with you and let them inform your view of the laws that govern our own lives today.